Okay. So we're back discussing another day in the life of a criminal defense lawyer. So how was your day today, Nick?
I had an interesting day. I was engaged in a hearing in Queens County where my client is charged with attempted murder and attempted robbery. Ultimately, this is a robbery gone wrong. Everything we're going to speak about here today is being alleged by the prosecution. My client is innocent.
So we don't expect you to basically say every sentence, it is alleged, it is alleged. We understand these are allegations.
Basically. Right? And I'm going to be talking from the perspective of the prosecutor. This is what they are alleging happened.
Right.
And then I'll get into the hearing and how we broke their case.
Oh, so you actually did the hearing today?
Oh, yeah,
well, I can't wait to hear that. Go ahead.
We took this case apart piece by piece. And prosecutor was shocked because I never spoke to her about the facts of this case because her offer for my client is 15 years. His max is 25. So at that point, when they give you an offer of 15 years, there's not much to discuss. It's save it for trial, and we're going to fight this case.
Yeah, unfortunately, many prosecutors, they get locked into their own narrative, right? And they can't really see the perspective of other narratives.
Exactly.
Right? And the question you always ask yourself as a lawyer is like, when do I tell them our narrative? Right? Do I tell them well in advance of hearings and trial? So this way they can prepare and calibrate what they're going to say and what they're not going to say. That's a strategic call, but I'm very interested about the facts of this case.
So what's interesting about what you said, I've never had a prosecutor ask me as much as this prosecutor did on this specific case, your client doesn't want a plea? Why is he not taking a plea? And I think she was somewhat expecting my angle today at this hearing, and it all came out. The truth came out that they really had no probable cause to arrest my client in the first place and charge him with this crime.
Oh, so she was hoping you didn't know, that you wouldn't sort of see that possible narrative.
Basically, and as the hearing was going on today, the prosecutor realized very quickly that I knew exactly what they were trying to pull, and I wasn't going to let it happen.
So tell us about this case.
So ultimately, it's three victims in this car who were almost robbed and their car was shot at. That happened, right? By who is the big question. So
it's you're not denying that they were victims of a robbery.
Attempted robbery, yes, right. And that their car was shot at, and in fact a bullet that went through the back window of the victim's car hit the headrest of the driver's car. Meaning, if that headrest wasn't there, that bullet would have went through their head.
So it didn't perforate the headrest.
No, I think the back window stopped it, and then the headrest was thick. It stopped the bullet. And in this case, everyone is lucky.
So this is purely an identification case then? Is it your guy or not your guy?
Exactly.
So tell us the build up, tell us what's going on with this case.
So ultimately, you have two perps, right, driving in a vehicle. One, the passenger is not wearing a mask, and the driver of this vehicle is wearing a mask. All right, it's alleged that they're following a white Audi, brand new 2023 Audi in Astoria Boulevard, because these individuals in the Audi are wearing very expensive jewelry, approximately $100,000 worth. It was corroborated afterwards when they spoke to the officers that they were all wearing Rolexes and diamond chains and rings. And the Audi at one point in Astoria pulls over to go into a bodega. The passenger from the perp's car comes out with no mask, and this is not my client, comes out with no mask and follows one of the individuals into the bodega, one of the victims. I guess.
Is that video surveillance?
So there's video surveillance of this co-defendant. You could see his face. You could see one of the victims walk into the bodega. They're standing next to each other, but the victim doesn't know that he's prey right now. He's being watched. Mm-hmm. The co-defendant is looking at this victim up and down.
But that happens everywhere you go today, unfortunately. You go to a nice restaurant, you're sitting there. If you have a nice watch, you pray to the wait, possibly pray to a waiter. You possibly pray to the bus boys. You possibly pray to the valet parking attendants, right? Because they all got text messages. You're going to have a guy coming out with a blue suit and a light blue Trump shirt like you're wearing today, right? So and he's got a watch on. And that's it. You pray.
Yeah. Well, that's, the safest way to stay safe in New York. And I get asked this question a lot as a criminal defense attorney. They say, how do you stay safe? It looks like crime is rampant now. Stay home. Get a little grill and put some steaks on the grill. Don't go out.
Well, that's certainly not you, but
Oh, no.
yeah, you can't lock yourself, because of lock yourself at home of what's going on. Remember, we had that incident. You and I came out of the restaurant, right? And I felt I was getting grilled by this valet guy. And you and I are driving, and you just got a new car, and we stop at a red light, like maybe 2 miles away from the venue, and we get a bump by this motorcycle guy, and
Hits our car.
Hits your car.
And then another motorcycle starts coming in from the front. You realize right away, Nick, we're being robbed.
Yes, he was hoping we were going to come out. So
they chased us for around 5 minutes.
So the right decision, it's interesting, we digress from your case, but the right decision at this point, right, because it is a crime to leave a scene of an accident, and you don't know for sure if you're getting robbed or not. So what do you do at this point, right? You have to call 911 yourself, and you say, look, I got into an accident. I'm not sure if it's real. I don't want to stop. I'm scared. So once you make that phone call, you're no longer leaving a scene of an accident. So what Nick and I did, tell them what we did.
So what's interesting, we were being chased for 5 minutes.
Well, because we decided to go to the precinct.
So we drove directly to the precinct. And what was interesting is that these two motorcyclists were following us.
Yeah, they didn't realize. They didn't know the neighborhood, so they didn't realize that we were on the way to the police precinct.
And they were following us up until we got to the front of the precinct. They saw we were in front of a precinct. They just sped off. Drove up on the sidewalk and sped off.
Right. So this was, it's because we were experienced, but there are a lot of people who are not experienced. He would come out. There were a lot of guys who came out of the vehicles and got beat up.
Well,
right?
What's interesting, the reason why we knew that day not to come out of the car is because my friend was at a wedding we were at. And he told me, he says, Nick, a motorcycle hit me in the back of my car. I was wearing a Rolex. I came out of the car to see what was going on. I got hit over the head with a gun. 3 other guys came, stepped all over my face, took my watch, and left.
Yeah, and you were just telling me the story like immediately after we get bumped, right?
Immediately before.
Oh, yeah, right. You told me the story before, and immediately after the story, we get bumped.
Yes.
And but we got lucky, but there's so many people who don't get lucky. And so this is actually good advice. If you feel that there's something strange about the accident you're in, you can't just run away, but just call 911.
And don't come out
of the car and just drive off. It's okay to drive off because if you're standing still there, they can break your windows. You just have to have a subjective belief that you're in danger, but that subjective belief, obviously, as you know, has to be objectively reasonable.
Yes.
And today, in what's going on in our society, the lack of police force on the streets, the rise in crime, the probability of people possessing firearms, that's an objectively reasonable, fear.
I would agree.
So let's come back to your case. We keep digressing.
So one of the witness 3, I'm going to call him, he doesn't realize he's prey. And he's wearing the most expensive jewelry. He's the guy. There's 2 other females in the car. He comes back into this Audi. And co-defendant comes back into the car that was following this Audi. And it's still not yet determined who the driver of this vehicle is.
Who's the vehicle registered to? Is it registered
to my client? No, it is not.
Okay.
But we'll get to that point. So the Audi continues to drive for approximately 5 minutes, and there's a canvassing of all the video footage in the neighboring stores, and it stops. So at this point, the co-defendant and the other defendant, who's my client, come out of the car. It's alleged that my client comes to the driver's side front window, and the co-defendant comes to the passenger side right front window. And they knock on the windows with guns. Mind you, the testimony is simple, that the individual who's my client walked up to the window wearing a ski mask, not a COVID mask, not a hat, a ski mask, and the officer testified that that mask covers 95% of the person's face, meaning only his eyes are visible. They knock on the window, they ask to put the window down and give us all your stuff. The Audi immediately drives off, steps on the gas and drives off. It's alleged that my client then pulls out, which he has his gun out, starts to fire at the vehicle multiple times.
So that's classic. That's classic statute. That's statutory and common law attempted murder. You're firing at a vehicle. You can't sort of use the defense. Well, I was just shooting at the vehicle. That's so foreseeable that somebody could get shot. But that's
especially since the bullet hit the headrest of the car. That's the only thing that stopped.
So he's not aiming. Yeah, he's not aiming at the tires. Let's just put it that way. So go ahead. So we're still on the prosecutor's narrative. I want to know how they sort of like led to the guy to identify how and why they believe your guy is the guy behind the mask.
Basically. So now they found the co-defendant very easily. They took the video surveillance from the bodega. They put it in an NYPD database. Turns out he's on parole. They send this picture to his parole officer, and the video footage is this your guy? The parole officer says, yes, this co-defendant comes into my office twice a week. I know him. I've seen him for already 2 years straight. This is him. So officers issue an I-card for him. But it's interesting how this lead detective issued an I-card for my client. One of the video surveillance...
So first they identified the passenger who was not wearing a mask because he was on parole. I just want to make sure I get it right, right? And then that led to identifying your guy as the guy behind the mask.
No, not so much. So the way they identified my client is not visually. They identified him through his mother's vehicle. So one of the videos that's following this Audi, that shows this Audi and this and the vehicle that's following the Audi catches the license plate of the following car, and the license plate is registered to my client's mother. So the detective types in the name, sees the vehicle, and sees that my client was issued a ticket in this vehicle. I asked him, how long ago was he issued this ticket? He says, I don't know. I asked him, do you know the mother of my client? He says, no. I said, do you know if she's married? He says, no. I said, do you know if she has a boyfriend? He says, no. I said, do you know if she has 10 boyfriends? He says, no. So ultimately, I'm laying the foundation right now that you only got to my client because
you guess it's her son.
It's her son.
And it could have been nobody else. That's basically what the police officer is saying.
And then I asked him questions. I said, you're the lead detective in this case, right? He's like, yes. So I said, you questioned the witnesses, you questioned the victims, you watched the video surveillance. He said yes to all those questions. I said, okay, when you questioned witness 1, who is the driver of the Audi, and my so-called client walked up to her, did she say what he was wearing? He's like, yes. I said, okay, what did she say? What was he wearing? Was he wearing a face mask? He says, yes. I said, what kind of face mask? Was it a COVID mask or was it a ski mask? He says, ski mask. I said, in your experience, a ski mask covers, 95% of your face? He says, yes. I said, so she explained to you that she could only see his eyes.
Did she identify the color of his eyes?
So I got to that. I took it very slow, and I got to that.
Because obviously you don't want to ask a question that the answer will kill you. So you have to thread.
I've reviewed the discovery in this case. I never ask a question that I don't know the answer to. My questions are all loaded.
All right, so go ahead, go on.
So now the officer's starting to look at me, with open eyes. I go, wow, this lawyer's getting to a point where I don't like where he's going, because ultimately he did guess, like you said. And I asked the officer, was she able to identify anything else about him? His tone of voice, his height, his weight, his skin color, any tattoos, any scars? He says, no, he had a mask. I said, okay. So I said, is it fair to say, is it fair to say, detective, that you issued an I-card for this individual solely based on the license plate of the vehicle?
So the only connection between the robber and the defendant is the vehicle that is registered to the defendant's mother.
Basically. So what the officer did was he pulled up my client's picture in the NYPD database. It's there already. He has contact with law enforcement. And he creates a photo array. So he takes one picture of our client and 5 other pictures of people who could resemble him. He sends that packet to another officer. That other officer calls in with victim 1. Victim 1 picks our client and says that's him.
So what you're talking about is a double blind, right? Photo array.
Yes.
So basically what that means is that, as I'm sure you know, but I just want to jump in, what that basically means is that this way a lawyer like you won't be able to argue that the detective sort of like spoon-fed or identified who he wanted the victim to identify. They do a double blind. The detective, who's the lead investigator in this case, who actually issues the I-card, right, who actually investigates, who believes it is your guy who's behind the mask, gives the photo array to another detective who doesn't know the facts, purportedly or allegedly doesn't know the facts, but who knows, right? Because they got their own brotherhood. I'm not, whatever. Look, there's always good, there's always bad, and there's always ugly in every field. And And so the double blind, this way they can argue that since the detective who didn't know about the facts, anything about the facts, who didn't know anything about who the alleged perpetrator was, who didn't even never discuss the case with the victim, cannot create a photo array that is suggestive. So it's right.
Exactly. But, our position throughout this hearing, and we're not done with this hearing. We just went too far into the day. We're going to continue it tomorrow. But our position is that picture shouldn't have even ended up in a photo array. They didn't have probable cause to create that photo array in the first place.
But how does she identify?
She doesn't.
I mean, let me ask you. So the interesting thing is, right? What obviously what you're trying to do is suppress the identification,
yes.
Right? If there's no identification, if you suppress the identification process, she cannot sit in a courtroom and say that's the guy, basically. Right? So basically, they can prosecute him, but they need some other evidence connecting him to the crime besides her saying that's the guy, because that's suppressed. Mm-hmm. Is there any other evidence linking him to the crime except for
his mother's vehicle? No.
So that means if you are successful in suppressing this identification process, then they have literally no case, because this case at that point, even now, it has built-in reasonable doubt. Built-in reasonable doubt means, like as professionals, you have to sort of like give him the benefit of the doubt, right? But if his entire face was covered, then the only thing she can identify is his height, right? But she can't do that because at the time when she's identifying his photo array, he's not standing next to the window, so she doesn't know the height.
You just reminded me of a question I asked. I asked the officer, I said, when you're conducting this photo array and the pictures in the boxes, I said, is it a picture of the whole person or is it just his head? And he explained that, no, it's just his head up to his neckline that's shown.
I mean, if, for example, he had a double head, I know it's like an absurd example. Yeah, that makes him extraordinary, right? So in the photo, if he has a wide head, a thin head, right? But he's wearing a complete ski mask. You can't tell those things. The only thing she could identify if he's got some extraordinary color of his eyes, but it was dark as well. So it's
no testimony. There was no testimony about the color of his eyes. So I didn't even want to open the door.
You did. That was smart. Yeah. So basically, that's a very, very interesting issue. But go on.
So no, that's basically where we stand right now at this hearing. And ultimately, if this case does proceed to trial, and even if the judge does allow her testimony to come in, we're going to have to handle her as a witness very cautiously, because we must remember that in front of a jury, she's still a victim, and in my eyes too, she's a victim. She was shot at, thank God she's alive. But people make mistakes.
So you're saying that, it's interesting you say that the identification process, right? The faulty identification process is really responsible for a majority of wrongful convictions in this country, because, like you said, a person's mind is not infallible, right? It is something that could make a mistake, and you could really believe that's the guy. I saw him, but your mind is mistaken, and it's taking you the wrong way. It happens to us all the time. For example, you look for a pair of keys in your hand, you think it's there, but it's not there. You think you did something and you saw it, but it's not there. So your mind can play tricks on you. So, for example, you have a lot of these victims of robberies, right? They say, yeah, but that's the guy. But it's still up to the jurors. And there's nothing wrong for a defense counsel to assess that entire situation. Was it dark? Were you under stress? Were you looking at the guy, or were you looking at the gun pointing at your head? Were you worried about your family at the time? What were you thinking about? Well, so what happens, unfortunately, right? So you look like the guy. You may not be the guy, but you just look like the guy. But when they identified you at that point, they have memorialized in their mind that you're the guy. And there's nothing you can do on cross-examination to dissuade them otherwise, because they believe 100% you're the guy. So the only thing you could do as a lawyer at that point, as I'm sure you know, because that's what we do day in and day out, is really talk objectively to the jurors and remind them of their everyday life, how we make mistakes about the things that our mind tells us that we did, but we didn't do. For example, you go to sleep, you think you closed the door, but you didn't. You think you parked your car on this block, but then you look for it for 3 blocks and it's not there.
Or you didn't close your sunroof and it rained in your car.
Exactly. So that's the mind. And that's what we work with every day.
So it's interesting. This case gets even more interesting. So both defendants have done time before. My client and the co-defendant.
I'm sure that worked against them in the issuance of the I card.
Yes,
but that's wrong. But it's okay.
I
Yes,
agree. But they've both done time, and they know the system. So when they arrested my client, obviously he did not speak with the detective. They brought him into a special blue room with cameras that you can't see. They read him his Miranda rights, and they said, "Do you feel comfortable answering questions?" He said, "No," and they could never use that against him. The co-defendant, who's a discretionary persistent, meaning he's done multiple jail sentences already, and the judge, if he's convicted of this specific crime, could sentence him to a life sentence at the end of it. It's discretionary up to the judge. He broke.
Oh, so he made a statement.
He made statements.
All right, but is he at the hearing with you? Is he cool?
So this hearing was a joint co-defendant hearing. However, at the end of this hearing, I'm going to be making an application to renew my application to sever pursuant to a Bruton issue.
All right. So the reason I asked you if he's sitting at the hearing with you, I was just very interested to know if he signed a cooperation agreement. Is he cooperating, or he just made a statement incriminating himself and the co-defendant?
He made more of a statement incriminating my client. Oh, that's what you said.
Right.
So he made a statement incriminating my client, saying I was with him.
But so in other words, I'm sure he said that your guy had the gun and he didn't, and the other guy didn't.
Yes, and that I didn't shoot. You could see the video. It wasn't me shooting.
Right. So he's not using a sort of like a factual defense, but a more of a mitigating factor. Yeah. I was there. Yes, I acted in concert. That's another.
So usually I see detectives, they would be more compassionate to an individual who was in a situation of wrong place, wrong time, when he would say, "Look, I went to rob the guy. I didn't know that my friend had a gun and he shot at him afterwards. That wasn't my intention." You got a no record, you're young, they'll buy that. They'll work with you if you want to speak with them. But this co-defendant has such a bad record. He's done things like this before. He's done serious time, double-digit time before. Detective wasn't buying it, and the co-defendant asked him, said, "If I continue to speak to you, am I going to go home right now?" He says, "Not a chance."
So he identified. So obviously he makes he makes an incriminating statement.
But he's not cooperating.
He's not.
He's not, because there's no.
So what do you do? And this is a rhetorical question for all the legal counsels that are going to be listening to us. But there are a lot of people who don't know the answer to this. What do you do if you could explain to the people? What do you do if you go to trial and you got a co-defendant who's made a statement that the prosecutors want to use in their case in chief, but that statement also incriminates, in addition to himself, and incriminates your client?
So what you do is, one, if the co-defendant is not cooperating, and there's video footage or evidence of his statements that would implicate your client, and that co-defendant is not taking the stand at trial as a witness for the prosecution, that's a Bruton issue, meaning there is a confrontation clause. Every defendant has a right to confront his accuser. His accuser, yes. Right. So ultimately, if the prosecutor was to play this video of the co-defendant at trial, and they're sitting at trial together with two separate attorneys, and this co-defendant is saying that my client did the shooting, I will not have a chance or an opportunity to cross-examine the co-defendant. He's not going to take the stand. So the prosecutor can't introduce that evidence. That's a Bruton issue.
He cannot introduce that He cannot introduce that in the trial against your client.
Against my client.
And
correct.
Since your client is sitting there with the person who made the statement, right?
Yes.
So basically, you're asking for severance for two separate trials.
Two separate trials. We'll go to trial on my guy. You go to trial on your guy.
Right. Unless the prosecutor sometimes says, "Okay, we won't use a statement," but that's very
She needs that statement. She needs that statement against the co-defendant, because that's one way to just really nail the coffin in this case. She's not going to have to do that much work.
Well, she does. He's on the video without a mask.
I know, but it wouldn't be the first time an attorney would go in front of the jury and say, "This is not my guy. Look at the video. Look at my guy. They look different." Especially since the case is almost a year old. People change in jail. He's sitting in Rikers. His diet's not the best. Stress.
Any DNA on the case linking your client to the scene?
Nothing was recovered. They were arrested weeks later.
All right. So what if the prosecutor comes back and says we want to have a bifurcated trial? It basically means that we have two juries, right? So it's one trial. Well, this way the prosecutor doesn't have to do double work. So they bifurcate it.
So at that point, before any of those decisions are made in a courthouse, they have to weigh the probative against the negative, right? And no judge is going to want to sit on one trial picking two separate juries and
Good point.
just clog up his calendar. It might very well be that she might try my case and the co-defendant's case in front of two separate judges.
Yeah, so the incentive, I tell you quite frankly, the incentive for the co-defendant to cooperate is really, really high at this point.
If his
especially
record,
especially if he's looking at life.
So that's what's interesting about being a discretionary persistent. It's up to the judge at the end of trial if you're convicted, if he's going to attach a life sentence to it. And you could only speculate, but you go based upon past cases and past rulings in that county. And there's mitigating circumstances for him since he was not the shooter. You know, the video footage shows he didn't shoot.
Yeah, so you're hoping, I'm sorry to interrupt, you're hoping for an objective judge who basically has a judicious temperament, right, who is not going to do the work for the prosecutor. And for example, in other words, you know, what if the judge puts pressure on the co-defendant, says, look, for me not to give you discretionary, persistent sentence, you need to cooperate. You've seen judges do that. You can't deny there are judges who have done that, right? And at that point, obviously, in my opinion, the judge has passed the threshold between the prosecution and the judgeship. But have I seen it before? Absolutely. Do I like it? No. But can I do anything about it? No. So you deal with it. What do you do at this point if the co-defendant is compelled to cooperate? Not necessarily compelled to tell the truth. Obviously, those are two different things, as you know, right? Mm-hmm. Cooperation and telling the truth on the witness stand is two different things.
So ultimately, I don't believe that's going to happen in this specific case. The co-defendant has a worse record than my client. They want him more. I don't want to get too into detail, but he's done some serious crimes before that fit the same MO, and they're planning on putting him away too if he cooperates and they give him 2 years. In their opinion, they lost. So talking about high sentences, what's your take on these violent crimes after trial when the judges set numbers of 20 years, 25 years? What's your take on that?
Yes, so the violent crimes in and of itself, right? They have this element to them that white collar crimes don't when it comes to sentencing, and most white collar crimes, it is retribution. Right? Retribution is part of every sentencing process, particularly in the cases you handle lately, right? Mm-hmm. Which is the violent cases, the drug, the homicides, the robberies, the burglaries, and where people get hurt. You know, when you're a victim and there is a conviction, in addition to specific deterrence, which we'll discuss with general deterrence, rehabilitation, there's also retribution, this concept of an eye for an eye, mm-hmm. right? This guy hurt me, right? And this guy hurt me, and I want him hurt as well. And you can't give a guy a year. Like, what kind of pain is that? So when you give a guy 15 years, 12 years because he shot someone, there's a sense of retribution on the part mm-hmm. of the victim, right? And so that goes a long way, I think, in the process of the judge's evaluation of a proper sentence. But obviously, as a lawyer, there are ways to go. There are ways to argue it, right? If it was a mistake, there's so many different ways to argue it. But in federal court, as you noticed, right, lately.
So what's going on in federal court now? With especially pharmaceutical cases, the sentences on pleas are extremely high. It's almost equivalent to violent crimes in the state.
Oh, you're talking about the latest sentences in the Southern District of New York, the Eastern District, yes. Right, where they're like upwards 10 years on white-collar crime cases where people used to get the same thing for the same thing, like 2, 3, 4 years, 5 max I've seen, right? This is on pleas.
So what do you think's changed in the last 5 years from when individuals were getting 3 to 4 years on these same crimes and now they're getting 15 years? What's changed in the last half a decade? I
mean, the last case you and I discussed, right? We were not involved in that case at all. We're not part of that case. Mm-hmm. I think the two lead defendants in a white-collar healthcare fraud case, one of them received 15 years. That's 180 months on a plea.
Yeah, that's a number that shocks the conscience.
Yes.
For the individual getting it.
Yes, of course. That's a moving number. Yeah, I agree with that's a lifetime.
Yeah.
That's a lifetime. 15 years. That's a lifetime. And then another person who's right below him gets 12 years, which is also a significant number, right? These are significant numbers that I have never seen before, and
on these specific cases,
on these types of cases, correct. And I think what really drives the new judicial process is, you know, in every federal case, obviously, when a judge sentences, there's certain aspects that every lawyer argues, right? You talk about that the defendant is unlikely to commit another crime.
Mm-hmm.
That's easy. And most people don't want to go back to crime after they get caught. They go through the ordeal of having to fight the case for a few years. Serving time for several years, a few years, right? Having the stigma of being a felon, felon not having any job opportunities. Most people are not recidivists. They're not going to go back to it.
Yeah.
So with that's the aspect of specific deterrence. So, you give a guy a few years, he's probably never going to do this again.
Makes sense.
And then, you send him to a federal penitentiary, they try to rehabilitate you. Most people will get rehabilitated. Argumentative, that's argumentative.
Yes.
Basically, some people may come out even more intelligent as criminals, right? Because the people who they associate with. But really, really, what I think that really drives the sentencing guidelines and sentencing in federal court is the concept of general deterrence. What kind of a message are we going to send to the world if we have a guy who stole, for example, $10 million, $5 million, and he gets out in 3 years? I think most people who are uneducated would consider committing a crime like that, right?
Very possible.
Yeah, they were like, listen, I come out, I'm a millionaire. So judges, they're confronted with a situation where a lot of these individuals who are before them now come from communities where they're almost glorified, right? Glorified to a point where they made tens of millions of dollars.
Mm-hmm.
Tens of millions of dollars. And so you do 3-4 years. So what? You come out a multimillionaire. So how do you send a message?
So you're saying now the judges are trying to send messages by saying no more, you're not getting 3-4 years anymore.
Correct, because they don't want the young generation to glorify these people, right? They want to send a message. So that's why when you are at a sentencing process in every federal case, most of them unfortunately are resolved by way of sentencing process rather than trial because they have such a high conviction rate. The sentencing process itself has to be so well thought out, so well put together to the judge to really take the defendant outside the realm of this general deterrence and say how his case really is not part of society, how this was aberrant behavior. In other words, he is not like everyone else, and everyone else is not like him. Mm-hmm. This was not in his character. It was really an incident that is beyond his character. And that takes a lot to put together. But that is what's happening lately. That's really the trend in federal fraud. Yeah.
Healthcare fraud.
Healthcare particularly.
Well, one of the issues I see that's very prevalent in today's society is social media. And I think social media is one of the key factors that actually made crime rise. And I'll explain why. 10, 15 years ago, even 20 years ago, if there was an individual who was successful and rich, his success wasn't portrayed on the internet for millions of people to see. His rich friends knew him. His rich friends who owned a boat just like him, hung out in the ocean, driving their boats around. But today you have young kids seeing nice watches, nice cars, nice women, nice vacations, nice trips, and they want it, and they want it fast. And that's why there's so many robberies. There's so much credit card fraud. There's so much insurance fraud, healthcare fraud.
Oh, you're saying because they're sort of like they see all this high life, high society, and they want to keep up, and they don't know how to do it.
Yes, and I think that social media is the cause of this higher crime rate that we have today because it makes young individuals want everything fast.
But social media is also important because it drives a person. It expands his his level of ambition because he sees what's possible in the world. So you have guys who grew up in the ghettos, right, for example, and they could not see beyond 2-3 blocks of their life, beyond where they come out of their buildings. But now the social media allows them to see the world, right, the full extent of what they can accomplish in the world. So social media, actually, and I differ with you on this one.
I think we agree with each
right,
other.
so right.
It's a sword that cuts both ways.
Correct.
It's a great tool for individuals who are able to be patient, understand that if you work hard and put in the effort, everything will come with time.